Welcome back to the Cordell and Men's Divorce video and podcast. I'm Scott Trout, CEO and Managing Partner of Cordell Cordell. And as normal, we continue to bring you information and specific topics as COVID is affecting all issues regarding family law, especially before, during, and after divorce for guys facing that issue, as well as the pandemic affecting unemployment. As we've seen latest, we're now over 40 million, I guess collectively unemployed. That always affects the ability to pay spousal support and child support, and that's something we're going to talk about today, particularly alimony or maintenance spousal support. But as always, as we begin, this is not to be taken as an attorney-client relationship, nor is it taken as advice. I continue to tell you that this is really speaking, talking points, educational. We want you to write these things down and go find an attorney who deals in family law, and you can write these questions down and ask those of the attorney. And if you obviously need a consult, you can consult with us at 866-DADS-LAW or find us on the web at cordellcordell.com. So today we have joining us Christopher out of our Nebraska office. Welcome.
Thank you, Scott. I'm happy to be here.
Well, we're glad to have you join us, and obviously, we want to hear, and guys watching and listening also want to know what's going on with the court system in Nebraska. You hear around the country, and I've talked to a lot of our Cordell attorneys from all corners, and it varies state to state. Some are closed, some are open. The word closed gives these notions that, the doors and the lights are off, but really what's going on in Nebraska?
So it depends really on what part of the state that you're in. In Nebraska, we've got kind of two major hotspots for the COVID-19 outbreak, one of which is Douglas County, which is the Omaha metropolitan area. The other, kind of surprisingly, is Hall County, which is Grand Island towards the center of the state. For a population of only 48,000, they're consistently listed as one of the highest outbreak places in the United States as far as per capita goes. So if you're dealing with either one of those two counties, you're more likely to see delays, more likely to see judges pushing court dates out, more likely to see very scant hearings being conducted only kind of on an emergency type basis. However, where I'm at, which is Lincoln, state capital, we're effectively acting as if it's normal, with the exception of almost all hearings are by either telephone or via Zoom, WebEx, some type of video conferencing system. My practice is not only in Lincoln, but kind of a lot of the more rural counties in the state, which is where I grew up. And a lot of those counties are utilizing Zoom and utilizing these telephone hearings for the first time. And while there's definitely some hiccups going on, the court system in Nebraska is working, I would say, close to 80% capacity. If you need a hearing, yes, they're delayed a little bit, where you would be looking at maybe 10 or 12 days prior to COVID-19. You're probably looking closer to 20 to 25 days as far as getting a court date. But it's not something where all court dates have been pushed out to the middle of November or closed in its entirety, as some states have seen.
Yeah, that's huge news. I mean, if you talk, gosh, for about 11 weeks now, I've been talking to attorneys from around the country, and, particularly here where I am in St. Louis County, Missouri, what typically a typical divorce would take 6 to 8 months, we're probably looking at double that, maybe even more. We have no hearings going on. It's just really very interesting, and I think it really boils down to the organization of court systems and their ability to just press forward. And that's really great news for guys in Nebraska who have pressing issues that they want to get things moving. And albeit you're doubling perhaps the days of hearing, but that's only by days rather than months and years. And so that's really good news for guys watching right now that have pressing issues like child support or alimony, because, as I mentioned early in the beginning here, the job data comes out every Thursday, and we have another 2 million added to the rolls. Collectively, we're over 40 million. Obviously, we're kind of leveling out around the 21 million mark of unemployed, and half of those or more are guys, and half of that, probably around 9 million, are guys that probably are looking at their paycheck. They don't have it anymore. They're looking at unemployment, and they're trying to figure out, how do I make an alimony payment? And so that's what we want to talk about today. And really, maybe you can kind of open the door to talk a little bit about, first and foremost, I think I always tell guys when they want to talk about modifying their maintenance or alimony, pull out your judgment, right? And take a look, and what are you looking for in your judgment and whether you can modify it?
So typically, at least in Nebraska, your state may vary, of course. The decrees are split up into different sections. Most of the decrees that I draft and most of them that I see where we're looking at modifying, there's a specific spousal support, maintenance, alimony section. In that section, there should be wording that either is completely absent or is very specific in how things will be modified from an alimony perspective. That could include a spouse cohabitating with a new individual. That could be, or sorry, former spouse.
Mm-hmm.
That could be 5 years or 10 years or 20 years. That could be once a certain amount is paid. That could be once other things are satisfied, such as the spouse earning a significant amount of money. Or it could just be completely silent, at which point the statutes of your state and the case law of your state are going to determine when you're able to modify and what exactly you're able to do. So in the event that you look at your decree, that you look at your order that would dissolve your marriage, you shouldn't necessarily be surprised if something is not there. In fact, if it's absent, that's probably most of the orders that I see. They're missing that particular provision for modification. And that just means that it's even more important for you to seek out professional legal advice for somebody who practices in family law, because at that point, they're going to know the laws, they're going to know the cases, they're going to know exactly how it's possible and what qualifications you would need to meet to make that modification or even termination in some cases.
Yeah. I mean, it is. It's many guys I know I've consulted with are desperate. They agreed to a fixed term, just call it 5 years, $500 a month, non-modifiable, and they don't know how to pay it, and they're looking to modify it, and there's not a lot of help we can provide them to modify something that is a fixed rate, non-modifiable judgment. Especially in Missouri, we have the same thing where it's either modifiable or not, or non-modifiable. And so you just got to pull it out, and it's the best 1 hour you're spend with an attorney to review the terms and find ways to get relief for guys. So, from a guy's perspective, they've now pulled out their judgment, listening to us and watching, and they realize that they can modify. And that really the question becomes, there are a number of ways to modify. We always talk about in all of the podcasts here, and including the virtual town hall, communicating with your ex-spouse first, putting them on notice that either you're unemployed, that you're having trouble making the payments. And don't you agree, maybe seek a consent to try to modify, see if there's an ability to do it without, ringing up the till and incurring a lot of attorney's fees before you go and file, right?
Absolutely. It's always easier to be nice first and mean later if it's necessary. It's a lot more difficult to start out mean and then turn around and try and seek some type of an agreement. Just a simple phone call to your spouse, especially or ex-spouse, especially if you tend to have a decent relationship or a decent co-parenting relationship, something along those lines. It's usually the fastest, the most economical way to modify alimony. In Nebraska, at least, you draft up an agreement, you just ask the court for approval, and the court takes it from there. They pretty much handle everything after that. Again, if you're able to start out nicely, the only thing that you're losing if they tell you no is, well, they told you no, then you get to go the maybe not so nice route or the more difficult route, and you still have options open at that point.
So, the word of caution for guys is always, well, I reached out, she agreed, and, we put it in writing that, that should be good enough, right? They don't need to go to court.
And in certain jurisdictions that I'm not licensed in, that may be the case. I would strongly doubt that. Almost always you're going to need some type of approval from the court, whether that be a quick one line from the judge just saying, this stipulation is approved, signed me, or whether that be something much more formalized. It's almost certainly going to need some type of approval from the court.
Yeah. And I don't, I think the message that I always say is, I'm not suggesting don't do it, don't get something in writing, because I think ultimately if you reach an agreement with your spouse in the nice way and you begin making payments that are lower than what's court ordered, with the prospect that you will file the motion to modify to get this approved, now you at least have a defense. If she comes back and says, well, no, he's paid less and I never agreed to that, well, now you have it in writing. And in some jurisdictions, it may be a good defense for you. And so I think it's, as you suggest, it certainly is a good thing to do, but it should always be followed up with a court approval to make sure that it's signed and sealed.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell and Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
So, if you guys have reached out now, they've tried to get their ex-spouse to agree, and they don't want to, which it happens, no doubt. Retroactive application. We've talked a lot about that in the nature of child support, where we've said, get filed soon because you want to give the court the ability to make any future order retroactive. And can you explain that in Nebraska, what that line of demarcation is, kind of when retroactive applies and what it really means?
So it's more or less going to depend on what judge you have, what jurisdiction you have. However, the, I guess, bright line rule would be, when did you file that? If you filed the document on June 1st, that gives the judge a hard date, even in September, October, where the judge can relate back and say, at this point, we definitely had a change in circumstances. It was brought to the court's attention. That is something easy for the judge to point to and say, you know what, we're going to relate it back to this date. On the other hand, if you filed on June 1st, but your, let's say, job loss started when COVID-19 started in late March, early April, it's going to be much more difficult to show the judge and to get, I guess, the judge to think that you're reasonable in most jurisdictions to relate it back when you had months where you could have done something and instead chose not to. So it's definitely more important to get things on file sooner rather than later to give the judge a hard date when they can relate things back.
Yeah. I mean, there's no reason to wait for guys, especially in this pandemic when you have major job loss, major income decreases. They think, well, we'll wait it out till this all blows over and becomes easier. You're really losing time, the advantage of asking for a decrease and, making it back to the data filing and giving the judge every potential form of relief for guys out there to give you some sense, that you can get something, even if it's not until the future, at least it dates back. And I think that's key. We've been trying to stress this for 11 weeks now is, you need to really consult and you really need to file if you've got it. But that really brings up the question, guys are saying, okay, do I have enough? What is the standard for a modification? We've heard, in my jurisdiction, in Missouri, it's a substantial and continuing change of circumstances. And we talked a little bit about that in my podcast yesterday. But is that the standard in Nebraska or what is it?
We use different wording. The first easy one is there wording in the decree that says this shall be a condition when you can change. If it's not there, then the standard is essentially the same as it would be in Missouri, but it's an unforeseen change in circumstances, not in contemplation by the parties at the time of the entry of decree that has existed for at least 3 months and is likely to exist for an additional 6 months. Essentially, it's the same thing where something big happened that you couldn't have seen. For instance, COVID-19, I lost my job for 3 months. Or I had a reduction in pay. A large object fell on me and crushed my leg. I can't work maybe permanently. The law changed, and there's no way that I could have known that the legislation was going to change. Or maybe my former spouse, who for 5 years has lived kind of a lone life, is now cohabitating with somebody, a new significant other, and they're sharing bills, they're sharing space. For some reason, her need for support has gone down. Those are things that you couldn't have predicted when you got divorced, but nevertheless, sometimes life happens. And when life happens, the courts in Nebraska, at least, generally have a understanding that, well, maybe you could come in and at least ask for a modification, whether that be a shorter term or a lower amount paid or both.
Yeah. I mean, I think that even the COVID, now we're almost 3 months into this, since really early March, we're at the end. And so even a positive diagnosis of COVID may qualify as a disability. Obviously it's got to be continuing in nature, but it may have led to a job loss or furlough. Those are the things guys are looking at. And I guess that's one of the reasons, you've talked about is it's job loss, disability, change of income. Any of those would probably trigger something so long as it's lasted more than 3 months.
And in Nebraska, that's definitely the case. Obviously, your decree will control, but if you don't have anything in the decree that says when you can modify, and you're just relying on the statutes, you're just looking for something big that what we attorneys call an act of God, that you couldn't have foreseen, and it's big enough to happen that it causes your entire life to shake.
Wow. So I guess the thing really is, we talked about this yesterday, and child support in my podcast does an increase in the recipient, the recipient of the maintenance, alimony, spousal support. Would that trigger the potential for a guy who's watching to say, you know what, I know she got a huge job increase with a big payday and a big bonus. Is that enough to potentially trigger emotional modified to decrease?
Absolutely. If you think of the purpose behind alimony, the purpose behind maintenance is you have one spouse who, for whatever reason, is at a financial disadvantage when leaving the marriage. That could be that a husband decided to stay at home and be a stay-at-home dad, or it could be a wife who gave up income in order to go back to school, or left school where she was going to be, or he was going to be a doctor, and instead has been working at your local fast food restaurant. In the event that your spouse, your wife, goes back to school and becomes a doctor, obviously that's going to make a significant change in most people's income. And that money that the husband is paying to the wife to kind of bring her back up to a level of a standard of living that they had during the marriage is no longer necessary. In many cases, she could be making more money. She wins the lottery and wins $10 million. The $500 a month she's getting from her husband probably doesn't make a whole lot of sense at that point, because $500 for her is a drop in the bucket, but $500 for him may be the difference between eating rice and beans or eating a hamburger that day.
Yeah. A couple other things that come up routinely in our virtual town hall when we talk about it is cohabitation. Guys will say, hey, my ex-spouse is now living with her boyfriend. Is that something I should be looking for, particularly in the decree that answers that? Or is that law in Nebraska that once she cohabitates for a semi-permanent basis, it's almost like a pseudo marriage? Is that enough to modify or terminate?
In some states, it might be. It's not enough on its face. It's not enough to just say she's living with a new person and therefore my alimony should terminate, unless of course it's in your decree. If it says in your decree, once the other party starts cohabitating with somebody else, then it terminates that obligation, then absolutely that controls. However, assuming that your decree is like most decrees and is silent, the trick is going to become proving that cohabitation is somehow benefiting your ex-spouse so significantly that it would justify, under the circumstances, your alimony being reduced or terminated. Again, the trick is going to be proving that. You're going to have to determine, are they living as if they are a couple, as in living together, sharing the same spaces, purchasing large items together, having joint bank accounts, things of that nature. Is she benefiting significantly financially from this cohabitation relationship? And if that is the case, then that's at least a reason to seek out an attorney and discuss this more further, or more fully, excuse me. But it does not necessarily on its face in Nebraska justify that reduction in alimony. Even if it does, the trick is you need to get the proof. You need to be able to show that this person is receiving that financial benefit. And because of that, attorneys have tricks up their sleeve where you can employ a private investigator, or they will have access to websites that the general public has access to but just doesn't know about. things of that nature, where the attorney could help you at least explore that option.
Yeah. And last question, I know we are running out of time, but now guys, I can imagine here watching, they're thinking, okay, I've been fortunate enough. I haven't received, a decrease in pay. I've got my job. I feel pretty secure. My pay hasn't gone up drastically. It's pretty much remained the same, but now I'm worried because my ex-spouse may have lost her job. And is that enough? Do I need to be concerned that she's going to take me back to court to try to increase the maintenance? And that's always a question that we get.
In Nebraska, I would say that is almost never a concern. The change in circumstances would have to be just so absolutely extreme to justify that, that I can't even think of a fact pattern where it would work. However, if you are concerned about that, it never hurts to have that opening conversation with somebody who is practiced in family law, so that you can at least get ahead of the ball if it turns out that does in fact become an issue. Just because it's unlikely to happen does not necessarily mean that your ex-spouse can't take you back to court and request it to happen. And if you have that developed relationship with an attorney, it definitely helps you get ahead of the game and get a good handle on whatever defenses you might have to her trying to raise that alimony.
Yeah. Well, Christopher, thank you. That's great stuff. I know in a very appropriate moment, especially when we're talking about the big unemployment numbers and the devastation of jobs. So thanks for joining and providing great insight for guys watching.
Absolutely. Happy to do it. Thank you, Scott.
And Christopher's always available to consult 866 Dad's Law over anywhere in Nebraska. You can reach out to our offices there or on the web at CordellCordell.com. And you can seek out more information. I know we just gave you a little bit of 15 to 20 minutes of information, but there's so much more. And each of your cases, particularly as Christopher mentioned, your decree has language in it that we need to review. And it may alter what we talk about in the path that we recommend for you. So reach out to us at CordellCordell.com or 866 Dad's Law. So again, thank you for joining us as we continue to bring you the latest information of how COVID-19 continues to affect family law. We'll continue to do this every day. Tune in on Thursdays to our virtual town hall. Well, you'll have the opportunity to join in live, ask questions of our panel, and get answers. So we'll see you on Thursdays. And until next time, have a great week.